Welcome back to another inquiry now. The Mokgoro inquiry has heard how top prosecutor Lawrence Mrwebi relied on hearsay evidence to withdraw charges against former crime intelligence boss Richard Mdluli. The commission is looking into the fitness of advocates Mokgoro and Mrwebi to hold office. NPA prosecutor Jan Ferreira testified that Mdluli had a case to answer to in court, but Mrwebi felt otherwise.
Bottom line is, if we had only the one piece of evidence, and that is the fact that he made a loan with Atlantis Nissan, the provider of vehicles to his unit, that would have been enough to prosecute him on and to, in my view, to obtain a conviction.
You then in paragraph 11 of the document, you say that the charges then pending against Mdluli and Barnard were fraud and corruption. And then you say new evidence had in the interim come to light and would require investigation. Is that correct? That's
yes.
You foreshadow that new evidence.
Yeah, that was basically evidence which we can later refer to if required, the evidence of a China trip that was undertook by Lieutenant Mdluli and various other people, as well as a trip to Singapore, and even much more later, further evidence came to light of wrongdoing.
But the subject matter of your memorandum and the subject matter of what was before Advocate Mrwebi and later made representations to did not relate to those issues. Is that correct?
Yes, not at all. This only related to the 3 motor vehicles.
Right. Did you get a, let's go to page 106. Sorry, 108, which is the next document.
Sorry, just repeat the number, please.
108. It's just the page just after your
I have that. That is a memo that advocate, that's the acknowledgement of receipt that I referred to earlier, dated the 26th of April on page 108, where Advocate Mrwebi in the first paragraph says, I confirm that on 23 April 2012 you delivered to my office a document on the above mentioned matter. He then goes on to describe the document. There's no doubt that it's actually in fact our memo. He then goes into the second page, which we found curious at that stage, and then he says he will not allow or consciously become party to any situation where the NPA, the SCCU or any other component of the NPA for that matter is being used or abused for any purpose unconnected with promotion or advancement of the interest of justice or the rule of law under the guise, be it through the purported exercise of investigative powers by the police or the purported of exercise of prosecutorial functions by the prosecutors. Now, taking into account what I've just said about the charges and what it entailed, this was very peculiar to us at the time.
Do you know what he was talking about?
Not for 100% sure, but I think he was talking about the allegations that was made that the police are fabricating evidence and they had the knives in for Lieutenant General Mdluli and they wanted to get rid of him and there was some sort of a conspiracy, but none of that was ever placed on paper in affidavits that one could rely on, not in the matter that we were dealing with here.
Well, the Mokgoro Commission of Inquiry has also just adjourned. ENCA's Govan Whittles is tracking the story for us. He joins us now live. Govan, so of course Jan Ferreira is highlighting what he calls bad decisions made by Lawrence Mrwebi.
That's right. There are 2 things that really stood out from today's testimony by Jan Ferreira, the senior prosecutor at the NPA, and that is that he believes that the case against Richard Mdluli, the former crime intelligence boss, was solid enough to, at the very least, secure a successful prosecution on charges of corruption, and he believed that Sean Abrams erred when he withdrew the charges of fraud and perjury against Mokgoro. So Jan Ferreira is central in both of these cases, and in both instances he says he believes the superiors got it wrong by withdrawing these charges. And essentially today he was setting out why he believed these charges should have been pursued and basically explaining the process that led to Lawrence Mrwebi deciding to withdraw those charges against Richard Mdluli and then Sean Abrams deciding to withdraw charges against Mokgoro after Jan Ferreira made those submissions.
Yeah, so any reaction from Mrwebi's attorneys about these allegations?
So essentially, Jan Ferreira said that Lawrence Mrwebi had no right to receive representations from Richard Mdluli and then decide to withdraw the case. In response to that, during cross-examinations, lawyers for Lawrence Mrwebi saying that his decision to withdraw the charges against Richard Mdluli were not necessarily taken based on the merits of the case, but were taken based on the procedural prosecution of the case. So essentially saying that Lawrence Mrwebi may have acted according to, by assessing the procedure that was undertaken when charging Mdluli, and even if he did so, he would have been within his rights to do so. And then a little bit of questioning, which was questioned by Justice Yvonne Mokgoro, was when the advocate for Lawrence Mrwebi asked Jan Ferreira whether he was aware of a narrative which said that Mokgoro Jiba and Lawrence Mrwebi were basically or colluding to get Richard Mdluli off, and that there was a closeness between Richard Mdluli and former President Jacob Zuma. He started this line of questioning leading up to a bigger point that he was going to make, but unfortunately the inquiry had to adjourn for the day. So he's supposed to continue his cross-examination tomorrow, when he will attempt to point out that the actions of Mrwebi and Jiba and at the time when they withdrew the charges against Mdluli were in line with what their duties are prescribed as in the NPA's policy for prosecutions.
Now, we know that Mokgoro Jiba actually responded to allegations from the state capture inquiry earlier this week. Today, there's been more allegations against her and Mrwebi. Any reaction at all in that regard?
None, besides Lawrence Mrwebi from time to time having a rush out of this venue to go see what was being said in the State Capture Commission. But they have said before that they deny the allegations that they were bribed emphatically, and that they're willing to appear before the Commission to clarify any role that the Commission may have thought that they had in the Bosasa matter. The Bosasa matter didn't come up at all here at the inquiry today. The only thing which did come up, which implicates Mokgoro Jiba, is whether or not Mokgoro Jiba is facing charges of fraud and perjury. If you can remember, Corruption Watch approached the High Court to have the decision to withdraw those charges against her set aside, and they eventually won, but that was overturned in the Supreme Court of Appeal, and now they've gone to the Constitutional Court to try and get that, to secure that once again. But today we heard from the legal representative of Mokgoro Jiba that the National Prosecuting Authority has not yet indicated to them whether those charges against her have been reinstated. All that they have done is refer the matter to the Northwest Director of Public Prosecutions, who gave his opinion on whether the charges should be reinstated, but a formal answer has not yet been forthcoming. And in fact, Shahan, I am now joined by the legal representative for Mokgoro Jiba, lawyer Zola Majava. Mr. Majava, thank you so much. So a little bit of confusion about whether or not your client is facing charges of fraud and perjury. Can you clarify that?
Look, I think as I placed on record, the judge directed us yesterday to contact the NPA to get certainty, because the spokesperson of the NPA had informed me and others that in fact a decision was taken. He also indicated that the docket was transferred to the DPP of Northwest in terms of Section 22(3) of the NPA Act, which allows the NDPP to do so. And he further confirmed that such a decision was in fact taken. And it was upon that basis that I then wrote a formal letter to the acting NDPP to say, look, is there a decision? If so, what is it? Make it available, because it would inform us how far we go when we cross-examine Advocate Ferreira on behalf of Advocate Jiba. That's what we did. 3 letters I wrote. None of those letters were responded to until the acting DPP of Northwest, Advocate Maema, confirmed to me telephonically that there is indeed such a decision. He has communicated it, having conferred with the maker of the decision, which is Advocate Smith, to Dr. Ramaite, and he says in terms of protocol it is Dr. Ramaite who must then confirm the decision.
But there has been speculation about what that decision is, and in fact I think you said that the spokesperson for the NPA had said that the decision was not to prosecute Advocate Jiba on those fraud and perjury charges. Is that what you're under the impression?
It's not speculation. I've just read into the record again what Advocate Mahema says. He says, firstly, he agrees and he confirms that which I placed on record. So implicitly, we now know that there is a decision not to prosecute. What he is simply saying is that formally, it is up to the National Director of Public Prosecutions to communicate it to the inquiry, because I had addressed the letter to the NDPP. It was only when he was not responding to me that I copied the office of the decision maker. As matters stand now, my client is anxious to know formally and see it in writing so that we can pass it on to the inquiry to make what of it, whatever they want to make it. But as I'm saying to you now, 2 officials of the NPA have confirmed that that decision was made as far back as the 28th of August 2018. You would appreciate the concern. When the proclamation establishing this inquiry was made in November last year, it means somebody had been sitting with a decision that potentially exonerates my client, or that informs her whether or not she's facing criminal charges. For us at this stage, we're not running away from her facing criminal charges. Either there's a decision to prosecute her or not to prosecute her. And if such a decision is there, let it be made known so that we can share it with the inquiry. Remember, the issue here that the inquiry is busy with is a broader issue of fitness to hold office. And it is important to see what a senior state advocate, who is senior to even the witness currently testifying, has to make of those reasons. Because once we have the decision and the reasons, it may well be that those are the reasons that we put to the witness. And without that information, we are basically hamstrung.
Thank you so much. That's Zola Majavu, lawyer for Mokgoro Jiba, here at the Mokgoro inquiry into a fitness to hold office. So that decision not to prosecute emanates from the High Court setting aside Sean Abrams' decision to withdraw those charges against Mokgoro Jiba. One would have thought that they would have been automatically reinstated, but Zola Majavu now saying that the Director of Public Prosecutions in the Northwest has decided not to prosecute. So a lot of bombshells coming out of the Mokgoro inquiry as well, related to the Richard Mdluli case, the Mokgoro Jiba case, and now we know that there may be a decision that Mokgoro Jiba shouldn't face charges of fraud and perjury. Shahan.
Yeah, bombshells has to be the word of the week. Thanks so much for that. Appreciate it. Govan Whittles in Pretoria.